everybody who's watching this webcast. This is Dr. Lev Grinman from Doctors for Providers. We're very fortunate today to be joined by two partners from the Lengea Law firm, Sarah Schickman and Sharon Adelman. They are going to be helping us to go through the topic of corporate practice of medicine today. I'd like to first talk to you guys, and I'm curious, how did you first come up with the idea? How did you start Lengea Law? And tell us a little bit more about yourselves.
Well, thanks for this opportunity, Dr. Grinman. It's really nice to be able to do this with you. And the company that you started, Doctors for Providers, is really helping the industry get more medical directors and get people connected to medical directors, which is awesome. So thank you for that. We started this company in 2019 after I was the general counsel of Juvia Aesthetics, which is a medical practice with 12 locations in different states, and Aesthetic Record, which is a software company that a lot of aesthetic practices use now. And while being the general counsel of those two companies, I saw this huge need for legal help in this industry across many states and many different situations. And so in 2019, I started this firm. And I've known Sharon for over 15 years, since we worked at the same law firm in New York. And we actually went to the same law school, University of Pennsylvania. And we just saw this great need in the industry for this kind of thing. And since it's such a growing industry and there's so many people entering the market, and we love helping people start their own business, we just thought it would be great to do this together.
That's fantastic. I love that story.
Thank you.
Today, I think you guys are going to help guide us through corporate practice of medicine and how it impacts medical spas and other medical businesses that are trying to get off the ground, and how to navigate around the CPOM guidelines. So Sharon, I think you were going to talk about corporate practice of medicine laws, sometimes referred to as CPOM. Can you go into more detail about that?
Absolutely. Yeah. Thank you, Lev. Dr. Grimman, I appreciate that. That's a great question. The good news is that in many states, anyone can own a medical spa directly. Some states, such as New York, California, and Texas, have strong corporate practice of medicine restrictions. In these states, physicians or other licensed healthcare providers may only provide medical services through a professional corporation owned by medical professionals that are licensed in that state. In the stricter states, the states that restrict the corporate practice of medicine, or CPOM for short, a non-physician or a non-full practice authority NP can get into the medical spa business through a management company or a management services organization. Some states have corporate practice of medicine restrictions, and some states actually do not, but they have corporate practice restrictions in other areas, such as dentistry, optometry. So the good news is that if you do form that management services organization, it may apply in different contexts.
Understood. And when you own, in states where there are corporate practice of medicine laws, does it mean that a owner of the med spa, for example, does that mean that they have to give up most of their earnings to the physician who owns the corporate practice?
That's a great question. And that's a very high priority item for a lot of people. The short answer is no. And actually, that kind of is a great segue into why that management services organization is such a good vehicle. In certain states, if you want to own a medical practice directly, there are co-ownership options. So for example, a physician and a non-physician who's a healthcare provider may co-own, for example, a medical practice in a state like California. In that state, the medical director generally owns a majority interest of that medical practice. A very popular alternative for a lot of our clients who are not necessarily physicians or not necessarily full practice authority nurse practitioners is to form this entity called a management services organization. So it's MSO for short.
Okay.
So the MSO, yeah, so basically they own 100% of the MSO. The MSO owns all the assets, the equipment, and brand name of the medical spa. So effectively owns the assets of the medical spa. And the physician or the full practice authority nurse practitioner would own that medical practice portion of the arrangement. So the MSO handles the non-clinical, owns the assets, equipment, the brand name, and the physician and full practice authority NP own the clinical medical portion. So everyone owns 100% of their own entity.
Understood. So it's a little bit like a division of church and state in the sense that the business owns the branding and owns the equipment, and then the physician owns the what's considered the clinical component of the practice.
Yes, absolutely.
Excellent. And I believe you guys have created a very useful chart or graphic to explain how all of these different entities within an MSO, MSA interact with each other, because I know it can be confusing.
Yes,
There it is.
perfect.
Do you mind going through this and explaining what all of these arrows mean?
Sure. Yeah, I know this chart has a ton of arrows. So this chart shows the flow of funds in a typical MSO MSA structure. So your question about whether the majority of the revenue has to be given up and given to the doctor is a good one, because in essence, here where there's a management company and that management company is owned by a provider, or maybe not even a provider, maybe a business person, the majority of the revenue at the end doesn't have to be given to the medical director, because all the medical director may be doing is occasional chart review and some good faith exams, whatever is needed per the state regulations. But the majority of the revenue ends up staying with the management company, because most of the work is actually happening by the provider, not by the physician. So what happens is revenue comes in from patient medical treatments, and that's the box, the green box on the left. And it has to go into the medical entity's account first in most states. In some states, it doesn't, but in a lot of situations, it has to go into the medical account first. And then through a contract called this management services agreement, the management company provides management services to this professional entity. And the professional entity, the medical entity, provides medical services. And so from this flow of funds, the money goes from the medical entity and then into the management company. And then the management company runs the business from the business perspective. It pays the rent, the business insurance, it does marketing, it handles the accounting, it pays the non-medical employees, pays the lawyers. And so the doctor usually gets a flat monthly fee, which Doctors for Providers has negotiated some really good fees in terms of their providers.
Mhm.
And then on the other hand, the management company usually takes whatever is the rest of the revenue for their management fee. And it's usually structured as a flat fee on both sides, both to the doctor and to the management company. But the management company can take some advances, can do loans, and can pay staff.
Interesting. Okay, so this is very useful in trying to understand the flow of money and how the two parties essentially interact with each other, being the business owned by the healthcare entrepreneur provider and the physician practice that is formed, looks like the PC or PLLC. So this is very, very useful. Thank you so much for going through that. Can you tell us a little bit more about how your law practice can help Doctors for Providers customers who are opening med spas or, let's say, IV hydration centers and are located in corporate practice of medicine states?
Yeah, sure. And I think Sharon and I will answer the question together. So for a typical setup for doing a practice or a new medical spa, IV hydration, wellness center in a CPOM state, the first thing that we would help our clients do is form their entity for the purpose of the MSO. So they need some sort of entity to be the management services organization. In many states, that entity could be a LLC, it could be an INC, it could be a couple of different entity types. Then we would do the operating agreements for that entity and if there are any partners within that entity. And then we would draft the management services agreement between that entity and the physician's entity. Or if people are using the contract from Doctors for Providers, we would review that on behalf of the practice or on behalf of the management company, depending on who we are representing. But what we do is typically do the formation of the entities, and then we do all the required documentation you need besides that, which is a lot of other stuff like consent and questionnaires and website policies and treatment protocols and compliance manuals. And we have a library of about 85 different templates that's included as part of our services, where basically anything that an IV hydration medical spa needs when they're starting, we usually have a template for already, since we've done this now over 300 times. And if we don't, we make one for them. But all the paperwork that's needed, all the filings, all the contracts to delegate procedures between doctors and nurse practitioners and RNs and estheticians, and all the different permits and things that are needed, that's what our firm handles.
I imagine that's very helpful for the business owner when they're first starting out, that you provide so much of the additional paperwork and documents that are needed to get their business off the ground, in addition to just the basic contracts that are needed. So that sounds great.
Thanks.
So the next question that I have is, how long does the process of getting an MSO, MSA structure going usually take?
Sharon, you want to take this one?
Sure, absolutely. That's a great question. So basically, the MSO, that management services organization, is essentially a rebranded, just basic LLC, limited liability company, or corporation. So the timeline for forming that is just based on the state filing timeline. So it generally takes a day or two to form. So in terms of that, it's relatively straightforward.
Okay.
And many people with whom we speak already have an LLC or a corporation formed. And it's a very interesting question, because they ask us, should we just form another MSO? And a lot of times we actually work with their existing LLC or corporation as the MSO. The MSA, that management services agreement, is just that agreement between the MSO and the medical director's professional entity. And we've done hundreds of these. So we have many of these agreements in place, and we revise them for particular transactions. So it's pretty straightforward.
Okay, so it sounds like that doesn't take a long amount of time. From my personal experience in seeing clients get set up, sometimes the rate limiting step could actually be the professional corporation. In some states like New York, I know it could take several months to get a professional corporation off the ground or to get formed by the state. So I know that we often urge our clients to get this process moving fairly quickly, because the professional corporation can be a rate limiting step. Is that correct?
Yeah, absolutely. And that's great advice. It's always better to get started sooner rather than later. New York is definitely one of the slower states with respect to forming that professional corporation or professional LLC for the medical director. Other states are not quite as backed up, but there is a little bit more of a delay generally.
Right.
Yeah, because they're asking for the license, and in some cases they want to notarize affidavits. So there's a little bit more documentation involved with that.
Right. One of the other things that we always talk to our clients about is the importance of actually retaining an attorney who is knowledgeable in the field, and not just going online and getting, boilerplate contracts and things like that, because I think you can get yourself in trouble by using something that doesn't pertain exactly to what your needs are. And because there's so many different documents that need to be looked at, reviewed, and formed, that it's always a good idea to have a knowledgeable attorney. And I mean, that's one of the reasons why we're talking to you guys and not just Googling this, is that having a good attorney is very important when starting your own business. And I'm sure you would agree with that.
Yeah, definitely. I think, at first, when starting your own business, right, there's a temptation to save costs on everything. And as someone who started businesses before, I get that. But inevitably, if you don't have an attorney working for you, eventually there's some complication or some problem, and then it ends up costing much more. So it's just better to spend the money. It's not so expensive to have an attorney from the beginning and have it set up correctly. Because I always say prevention is cheaper than correction. Same with Botox, right? It's better to start doing some aesthetic treatments earlier on, rather than say, well, now I'm 60 years old, because then, there's not that there's not that much you can do in terms of prevention. It's more about correction. So here, all we do is really geared toward prevention, so that if the nursing board, the pharmacy board, the medical board comes to visit, which they occasionally do, you're well prepared and you have your set of documentation, and you know exactly what to do, rather than being kind of caught in the middle of, you know, something non-compliant. So, and in terms of the entity formation, it does take a long time in some states, but what's nice is that, let's say a doctor's PLLC in New York may take 3 months, but once they have it formed, they could use it multiple times. They don't have to do one PLLC per, you know, arrangement. So it's just maybe a longer initial process in some states, but then you're not really, you're not just doing that for one-time use. And same thing with a management services agreement. Once we set a management services agreement up for a client, let's say they decide to open a second location or do business in a different state, only minor adjustments are usually needed. We don't have to reinvent the wheel or do a lot of legal work. All these things that we're doing are kind of reusable, which is pretty good.
Excellent. And I completely agree with that. I have personal experience starting a couple of different healthcare related businesses. And I've always found that even though legal advice may be one of the more costly things as part of the process of starting the business, essentially, though, you have to look at the starting a business as, and all of these contracts, as laying the foundations of a house. And if the foundations are faulty, the house can come crumbling one day. It may not happen a month from now, but it could happen a couple of years later. And so if you want to be as protected as possible and to have the most solid advice and contracts in place so that you know you're doing everything correctly, so that your financial future is secure and that you're just doing everything by the book. Is there anything else you guys want to add about MSO, MSA, or just, you know, medical spa law in general that might be useful for our clients?
Yeah, I mean, essentially, I think it also just kind of goes back to that the importance of working with lawyers who do this day in and day out. You know, this medical spa is essentially a hybrid business, safe haven, medical practice. So, you know, while it's a business, it's also highly regulated as a healthcare business. So those are, you know, kind of working with that intersection of being practical on the business side while also covering all of the regulatory healthcare compliance issues is definitely something which we specialize in, we focus on, and it's very useful to work with people who are specialized in this area, as it is a very niche area. So I think that's just something to keep in mind with respect to this area of the law. It's not that easily locatable on Google. A lot of the answers are within the boards or in case law, but it's a very interesting niche of healthcare law and corporate law kind of mixed together with this aesthetic component to it. So it's a very exciting industry, and there are definitely certain legal aspects that are definitely a good idea to be covered. You know, with respect to that MSO, MSA structure, as Sarah mentioned, it's very straightforward once we start the process, and it can be replicable, you know, once it's formed properly as well. So.
Wonderful. Well, I'd like to thank both of you so much for coming on and talking about this important topic that is commonly faced by our clients. We look forward to working together as we have already. And I'm sure a lot of the people who are going to be watching this webinar are going to be fascinated by what they hear and find this very useful. What is the best way to contact you guys? And we'll have your contact information on our website. Do you guys prefer that people email your law firm, call you? What's the best way to get in touch?
Yeah, so we try to be very modern with our communications and very responsive. So people can email us, they can call us, they can even text our main phone number.
Okay.
And we try to respond within a day. Our website is lengealaw.com. People also reach out to us on Instagram, Facebook, even TikTok. So we try to be, you know, wherever our clients are in terms of the social media platforms. But there are lots of different ways to get in touch with us, and we look forward to helping you, even if you know, it's just one of our 15-minute consultations. We really take a lot of pride in doing those and helping people, even if it's just 15 minutes.
That's awesome. Hey, guys, thank you so much for doing this, and we'll speak soon. Thank you.
Thank you.
Thank you.